Hello, everybody. It's it's Monday, the 21st of July, 2025, and sadly, Mike can't join us tonight. He's got other things to do. Um, but I'm lucky to have Karis and Shannon here. Thank you for joining in. And I've got a couple of things. If anybody's had a chance to look at the show notes in advance of what we're of watching this, you'll see that I have set up a couple of things to talk about. One is a couple of new cases from the database, and then I thought I would talk about the problems faced by successful asylum seekers in obtaining accommodation. Um, you may think, oh dear, that's a bit specialist, and I'm not an asylum seeker, but it's quite. I mean, it's interesting anyway because you see how local authorities mess around when they get a chance. And also, I'm not sure if it was Tony Benn or some left wing wise person said once that you have to keep an eye on the way that people treat asylum seekers and migrants because it's a test for how they're going to treat you later on if they get away with it. So, bearing that in mind, oh, hello, no, we've got a couple of hellos. Hello, Tiff, and hello, Katie. Sorry, I'll go to the comments section. And oops, so Tiff, we've got a hello everyone, and Katie saying hi. So great. I hope if there's any questions, remember, please express it in the third person and don't give any personal data. And also, if you can, please like the video and subscribe to the channel if you haven't already. So I'll go back to the show notes now. And do interrupt if you want to, but I will just keep talking otherwise. So I've if you remember, I've got this database which is in Notion, which everybody should be able to access via the link which I just clicked, which you can get from if you go to William Flack blog, you can usually get it from there, or you can get it in the. I think you can get it. Uh, in the details of the videos. But if you can't, it's here as well in the resources section of the blog, case law database. And there's different views. I'm sorry if people have heard this before, but it does help. So if you want to just see if there have been any interesting cases coming up, then you can go to this view, which is added in the last week. And you may say, hang on a minute, some of these are that looks like that one there is 12 years old. But these are just cases that I've added in the last week. They're not cases that have happened, but you can see some of them will be cases that have sort of come to light in the last week. And you can tell by that I've sorted them by the year that the judgment was given. So you'll see the genuinely recent ones there. And remember, if you're interested in a particular subject, you can look for you can do a search using this bit. And so let's say we wanted to have all cases with Waltham Forest. There you go. There's quite a lot in there, as you might imagine. So what I do, I'll try and do every week is just highlight new cases that are in here. And the ones I wanted to talk about today, I'm happy to talk about other ones, but just to keep it fairly simple, to go back to here. There's this case here, which is an interesting one, which I just saw on Nearly Legal within the last couple of days, and so I've added this. And he said Giles Peaker or whoever wrote the post on Nearly Legal said that it's an interesting case, and he's right because it deals with the issue that we've talked about a few times on here, which is the one where the council say, okay, we accept your accommodation is unsuitable, or we accept that you should be provided with alternative accommodation, but oh dear, we haven't got anything suitable for you. And the question is, when can you go to a judge and say, I want you to order them to give me accommodation? Now, common sense says you have to allow them a reasonable amount of time. For instance, if you get a decision saying, yes, you're homeless because you're occupying unsuitable accommodation, and it gets sent to you by email at 2 p.m., you can't really expect to rush into court at 4 p.m. if you haven't been provided with your accommodation yet. Or even to send a judicial review pre-action letter would be a little bit early. But the question is how soon is now, as it were. And this case deals with it. Or well, let's just deal with the facts of this case. That it's not that encouraging in terms of the law, but this the applicant in this case have been waiting for a very long time. Um, it looks like since I'm not even sure it wasn't even as long ago as 2022. Um, but the council had said they'd give her somewhere else and had consistently failed to do so. And so eventually her solicitors issued judicial review proceedings, and it came before a judge who had to apply the rules that were set out in Imam, or consider the factors for deciding when to make an order requiring the council to accommodate, or as lawyers would say, a mandatory order. And in this case, he said they had to, or she, was it a she actually? I apologise if it was. She said that in fact, there is a post. Oh, in fact, I don't know. This is the nearly legal post. Unfortunately, there isn't a record of the actual judgment, I don't think, because it's not been published yet. But they nearly legal has seen or have seen the actual transcript. Uh, yeah, so the what the judge had to decide was these five things, which I put in the note here. So if you when you're looking at when to ask for an order, you have to think about these things. So number one is whether the council has a contingency fund for dealing with unexpected expenditure, and if so, why it hasn't been used to accommodate this applicant. Most councils or most organisations should have some sort of emergency fund um, which would deal with this type of situation. And the way in which they could spend the money ranges from finding a private rented place or even to buying one. I have heard it said in the past, not necessarily by judges, but by lawyers, well, why don't you go out and buy a place if you haven't got any? Which seems quite a drastic step to take, um, given that it's, in London, it's hundreds of thousands of pounds for property. But um, that's what the law says, you have to house them. The council must provide suitable accommodation. So there comes a point where money stops being a barrier to doing that. So I think most councils will have a contingency fund, or if they don't, then that's pretty bad, and they should have that held against them. Issue number two, and this is quite an interesting one. If the council say, please, can we have some more time? We've been doing everything we can. The second factor is that the court can't create, and this is a sort of legal way of putting it, the court can't create an encouragement for the council to ignore its statutory duties. So there comes a point where if the court sort of says, "Oh, go on then, have another, have a bit longer, have a bit longer," uh, they're almost encouraging the council to act in an unlawful way. And so the longer the council has sat on its hands and failed to comply, um, then the more like with its mandatory duty, the more likely the court will be to make a mandatory order. Um, Now, obviously, these are completely subjective terms, really, aren't they? Because if you say how long, how long is a long time? I mean, if you're holding your breath, 1 minute is a long time. But if you're talking about geology, then 56 million years isn't that long. So we then come on to the third factor, which enables you to apply that. So it's the impact of the failure to provide accommodation on the applicant. And in this case, a disabled applicant had been traumatized because of a fire at her temporary accommodation, which she couldn't get out of the building and she had to be carried out of there. So obviously she was terrified that this might happen again. So it was held that this should be treated as urgent. And then there's the next number 4 is whether there's any sign that the council are actually going to do anything. And if there is nothing on the horizon, again, that's a reason for making an order. And the last one, yes, this is an interesting one, because councils may say, look, it's all very well this person getting a mandatory order, but we've got loads, and we're messing around loads of other people as well. And if we help this one person, then the others are treated unfairly because she's jumping the queue. Um, but the court says there comes a point where that's ignored as well. So, in fact, what they say about number 5, unfairness to others, it says Tower Hamlets' witness statement referred to other families in need of accommodation, but gave no reason why a mandatory order would result in unfairness to others. You may think, though, well, they just took it for granted. If this person gets accommodation, it's less likely the other people will get it. Or why it would give undue priority. But I think the court's entitled to say, if this person's been waiting a long time and it's urgent, then you can't tell me it's unfair to give them what they should have. But if there are other people, say there was a person in an even worse situation who had a greater need and had been waiting even longer, and you could produce evidence about them, then maybe the court would say, okay, how's that person first? But in the absence of something clear, the court has to make an order. And in this case, the judge made an order requiring the council to house in 2 weeks, which is pretty strong, really, if you think about it. 2 weeks is pretty long, short time to find accommodation if you hadn't got any. You may ask the question, what happens if they haven't done it? And it starts to get into the realms of unreality in a way. It's a bit like sort of, if a company, if people get killed by a limited company, and a company gets found guilty of corporate manslaughter or something, it's not, nobody's, you can't send the company to prison. But what you can do is apply for the director of housing or some other appropriate officer to be committed to prison for contempt of court, which sounds a bit crazy. And hard to visualize. Some sort of people, the police coming to arrest the director of housing in particular council, but it is a real risk. I'm not sure if anybody out there knows of it ever happening. Please let me know. I'd be really interested to hear about it. But I do know that there was a story that the director of, this is going back a few years, and it related to disrepair cases where Lambeth Council was always getting ordered to carry out repairs and never did. And so people were applying to commit the director of housing to prison. And in order to do that, you have to serve the application on the director personally. So you have to get a process server to walk in um, and hand it to them. So it was said that the director of housing had a special door behind his desk where he could exit the office as soon as he saw somebody walking in he didn't know who was likely to serve him with something. He could escape. Um, so they do take it that seriously that they will make efforts. But I think if you ever got to the stage where the application was being made, it would somehow miraculously the council would find accommodation. And it'd be interesting to know what happened in this case because as with most cases, the judgment was actually yes, the judgment was given on the 29th of April, which means that hopefully this lady has been given her accommodation, or there's an application in the wings for the director of housing to be committed to prison. Um, so I can't see any comments on there. I ought to leave a comment saying, did she get somewhere, or if not, what's happened? So that's that case, unless anyone wants.
Can I ask you a quick question?
Yes,
on that
please
one?
do. Yeah.
Just in terms of the 2 weeks from the judge and 2 weeks to get the person housed, do you not think that leads to potentially like an unsuitable offer of accommodation being given, or do they discuss what would be suitable within that hearing and therefore that like mitigates that chance?
Good point. And the answer is yes, they would have to consider whether it's suitable. And it came up in this case because one of the things that Tower Hamlets said, and it's here, is that they had made 6 offers of accommodation already. which had all been withdrawn and accepted to be unsuitable. Um, and so they tried to. So obviously they were aware of what would or wouldn't be suitable, and they tried to rely on the fact that they'd made these 6 offers as a counter argument to the one about you've been sitting on your hands. They said, "Oh no, we haven't. We made these offers," but the court said that the fact that they'd made all these, yeah, it says the second factor is that the court, sorry, in this case, Tower Hamlets argued it had made offers, so it wasn't sitting on its hands. But the court noted that the pattern of unsuitable, sorry, the court noted the pattern of unsuitable offers and said that not checking the suitability of properties offered was in effect the same thing as sitting on your hands. So that was good. Um, so yeah, they do have to consider that. Um, they may try and argue. I mean, it's interesting that they accepted that the accommodation wasn't suitable. Where it gets a bit more complicated was if they said, "Well, we think this is perfectly suitable," and our medical advisor says that, and then you're into a different argument than you are if they've accepted it as unsuitable. Um, so that's an interesting one for anybody thinking what to do. If I've got a couple of cases like this now where I'm waiting for them to provide suitable accommodation and nothing's come up, and I think it's been about 4 weeks now, and I'm at the point of sending the pre-action letter. Um, it's not mega urgent, but so I can't really say it's an emergency. But it's one of those situations where they're in a property full of mould and the children's health is at risk, so it is dangerous. Um, I'm sorry if I sound laid back about that. You might think I should be treating that as an emergency, but I'll let you know if I do have to issue on that. But at least I can rely on this case, which is very useful. Um, so uh, I've got a message from you, Shannon. Is that my your Zoom
So
is apparently playing out?
Katie
Was
just
oh God
pointed out
saying
that I was echoing. So, but I think I fixed it now. So, Katie, if you can let me know if I'm
yeah.
echoing, I don't hear it at my end, but
Yeah, thank you, because we were checking this out before, because we had problems in the past, particularly with Mike's video echoing, and I thought it was because I wasn't wearing headphones, so it was coming through my end. So I thought I'd sorted it. But if Katie, if you could, Katie, it's not your fault. No problem. It's not your fault. Uh, does that, Katie? Does that mean that you can't? Sorry, Katie's put a comment on here. If nobody else can see it, that it's not your fault. But does that mean you can't hear the echo anymore, or does that mean you think the echo is not Shannon's fault? Oh, it's a lot better. Great. Okay, I'll carry on then. So if now this case is only the second case is of particular interest in disrepair uh, cases. So I won't. I appreciate this is mainly about homelessness and not about disrepair, but it is important in terms of getting repair work done. Um, so let's see where it's gone. It's the case of uh, it's a 2024 case, I think, or even, oh, hang on, have I done something wrong? Yeah, I think we go back to here to the show notes. Uh, see if I just go, sorry, probably lost where I put them. So if I go to the show notes and then back to here, yeah, Hassan v Bristol City Council. Now, this case, as I say, I won't talk for as long about this case, but it is important. And it's about the legal right of tenants to, or the right of tenants to issue legal proceedings when the landlords don't carry out repair works. The current situation is that they can issue proceedings and often, very often, need to, and they the local authorities have been desperate to try and stop this happening because there's a couple of reasons. One is obviously they might get ordered to carry out repair works. Two, they might get ordered to provide compensation. And three is they might get ordered to pay costs. Now, what they've tried to do, and you get this in judicial review as well, is to say it's not appropriate for you to go to court. What you should be doing is using our complaints procedure. Now, anyone who's dealt with local authority complaints procedures knows that this is quite a slow process. And also, as you'll see from Mike's video about how to make a complaint, uh, that it's likely that the first response will just be a sort of useless one and nobody's looking at it seriously. So you then have to take it to stage two, where you might get somebody sensible looking at it. But the chances are that it's going to be uh, less fair than having a judge look at it. And the chances of getting a decent amount of compensation are much smaller. Now, there was a case about 2 years ago. It's probably fine. It was much longer ago. It was called Churchill v Merthyr Tydfil Borough Council. Yes, here it is, 2023. So it was 2 years ago. Now this case was. I think I did a blog post on this when it came out because the local authority and those acting for them were making a big sort of song and dance about how this case was authority for the fact that claimant tenants had to go through the complaints procedure. And so they was thinking, yeah, we've stopped the floodgate, we've closed the floodgates, they won't be able to do it. And I read it and I thought, this is a bit odd. It doesn't say that at all. What it says is that the court can, in some circumstances, adjourn the proceedings to allow the complaints procedure to be dealt with, I think, or to use alternative dispute resolution to be dealt with. So that was different from saying you have to use the complaints procedure, where you'd literally just get struck out or put on hold as soon as you applied to the court. And in Hassan v Bristol City Council, which is a county court case, so I've got this copy of the judgment. I don't think it's available anywhere else or online anyway. But what the court basically said here was that so the council applied for an adjournment of the proceedings to allow the parties to use its internal complaints procedure. The claimant, the tenant, did not oppose the stay, but said it should be for no more than 6 weeks, and it should be for mediation rather than using the internal complaints procedure. And I'm sorry if I've lost you with jargon, but mediation, and again, sorry if I'm assuming that people don't know basic legal stuff, but mediation is where you get it referred to some independent person who will try and sort out the dispute. Really appropriate in cases like neighbour disputes. I think in family disputes as well, there's a tendency to try to send it to somebody sensible who'll get everybody in a room and say, look, what can we do to sort this out? Uh, that's different from the internal complaints procedure where you get some very defensive person possibly signing the letter written by the person you're complaining about. But here they said, yes, we'll agree to 6 weeks and mediation, which they'd already proposed in their letter of claim. And so the council got into trouble here because it was held that the council's internal complaints procedure was not independent and therefore it wasn't fair and there was no equality of arms, which spelling mistake there, to if you went to the internal complaints procedure and it didn't allow for resolution of all of the matters, including costs. So the council's application was dismissed, I think. So that's good. So if anyone's ever involved in a disrepair case where you've got people talking about Churchill and Merthyr Tydfil and saying, "Oh, you haven't gone through the complaints procedure," you don't. The answer is you don't need to, and Hassan is authority for that. But it is a good idea when you send what's called the disrepair pre-action protocol letter. You have to send a warning letter to the landlord. It's a good idea to suggest mediation for a limited period, and then nobody can say you're being unreasonable. So that's quite an exciting case and reassuring in that it would be a worry if nobody could go to court to get an order for in disrepair proceedings. So unless anybody's got any questions about that one, I'll finish talking about cases, and I will talk about the other thing I wanted to talk about, which is problems faced by successful asylum seekers. Um, and well, I suppose one of the many, getting leave to remain in the UK. I mean, it's a great um, achievement, and many people don't succeed. So that's great, but it is the beginning of other problems. Um, it's there's difficulties integrating, and the initial one is getting accommodation because, and I'll click over to the post here. So if just to summarize, I won't read out this whole thing. If people are interested, they can read it in detail. But I'll just talk about what's in here in general. But there was a time back, the sort of government quest to crack down on asylum seekers, which we've seen a lot of in the last few years about stop the boats and all this stuff. That's been going on. I mean, since about, well, I mean, probably forever, but it really became a legal issue back in the mid 90s when the then Home Secretary Michael Howard um, in, introduced a provision to say that if you hadn't applied for asylum at the port of entry, um, you would be denied any housing or welfare benefits. Um, and that was back in the days when the catchphrase was bogus asylum seekers. That's sort of gone out of fashion a bit now because they just sort of, I think it's illegal. They, yeah, that's right. They shut down all the ways of legally applying for asylum in the UK. So now they're called illegal asylum seekers or illegal migrants because you can only really apply here by entering illegally. But back then it was bogus asylum seekers. So there were people on the street who weren't getting housed because they hadn't managed to apply at the port of entry. There's lots of reasons why people didn't apply at the port of entry. If you've just spent ages getting over to the UK and escaping from some war-torn place, and you're very paranoid, well, not paranoid actually, you're genuinely, legitimately concerned about authorities, you don't really want to risk getting put back on the next boat by saying, hello, I've got no right to be here, but I'm claiming asylum. So you sneak in and then claim asylum later. Uh, and in a nutshell, there was a case back in about 1995 called M and Hammersmith. It might even be here, but in that one, they said, look, what's going on here is you're treating asylum seekers worse than prisoners were treated in the Napoleonic Wars because you're just throwing them on the street with no form of support. And so the initial cases said that social services had to house the asylum seekers under the National Assistance Act, which was the piece of legislation that was then in effect, which was a sort of ancestor of all the homelessness legislation and what have you. Because back in 1948, when it was introduced, it was felt that one act could provide for all sorts of support, but that's another story. So they said social services have to house under the National Assistance Act, which led to an enormous, a bit like when the no recourse to public funds stuff was issued, an enormous amount of people were getting housed by social services. And so social workers were spending their whole time basically becoming housing officers. Uh, and when Tony Blair came into power, they said they were going to change this by introducing what was known as NAS, which I think is the National Asylum Service, or forgive me, I don't know, but this was the Immigration and Asylum Act, or the Asylum and Immigration Act 1999, which basically said the Home Office will house all asylum seekers pending the outcome of their application. And that's what led to people being put in hotels. You've seen a bit of stuff in the news recently. Those hotels are the Home Office organising, but they also put people in normal accommodation, as well as particularly unpleasant places like that. They had was not a barge, what's the word? Some sort of floating prison type thing, which I'm pleased to see has stopped being used, and also asylum, sort of military camps and things, which which is all bad. But the long and the short of this, what I'm talking about now, is that the problem arises when you get asylum because then you stop being entitled to uh, asylum accommodation, and you're then expected to apply for the accommodation which you're now entitled to under Part 7 of the Housing Act 1996, which is brings us back to the area we're probably more familiar with. Now, if you think about gatekeeping and general sort of levels of unhelpfulness, that's what faces most people, and that's people who speak fluent English and aren't suffering from whatever post-traumatic stress disorder you'd be suffering from if you came from some of these places. But people who apply to local authorities after asylum are often in a very weak position, and unfortunately, local authorities tend to take advantage of this by turning around and pointing at the door. And um, so I get contacted by asylum or immigration advisors who are unfamiliar with housing law, saying, "What can you do to help this person?" And the answer, like most of these sort of situations, is to threaten judicial review proceedings and then issue them if necessary. Um, and so that's what this deals with. And it's a bit similar to the situation I've put here that young people used to face. If you were in care, like you was taken into care when you were 16, say, and the council put you with a foster placement or somewhere else, the danger was that on your 18th birthday, you might get a card, a sort of figurative card from the council saying "Happy birthday," and by the way, we're going to kick you out of your accommodation next week because you're not our problem anymore. And then the young person who was facing a similar vulnerability and inequality of arms, to use the expression we used before, would be then applying to a local authority and given some nonsense about we don't do housing here or and turned away. And so a lot of young people were sleeping rough. The law was changed to mean that local authorities had ongoing duties to look after looked after children. Um, but it's an interesting analogy. I've said asylum seekers have got it worse uh, because they often, as I say, they don't speak. They face the same culture of refusal on the part of the housing department as the young people. They also face what I think we'd have to accept is the additional hostile environment created by central government for all migrants. It was initially directed at illegal migrants, but I think we've seen with sort of UKIP and even the general dialogue on things like GB News that it's basically all migrants are seen as not to be encouraged. And so there's this hostility. And then many migrants only speak limited English and may be suffering from mental health problems, which make it easier to deny them. And also, I mean, I'm not wishing to be unkind to council staff who have a difficult job, etc. But the other problem is that many councils seem to have be still operating as if we're in a COVID lockdown when it comes to homelessness. The I drove I was in Wandsworth the other day, going down Garrett Lane. If anyone who knows Wandsworth will know that until not that long ago, there used to be what was called the Homeless Persons Unit on Garrett Lane, which was a building where you could go in, and if you were homeless, you could sit there and wait to be seen by somebody in the confident knowledge that you would probably be given somewhere that night. They would sort you out, and you just had to wait, possibly all day. But now I saw that's now a block of flats, and that's gone. And I think with like most councils, ones would probably just do this thing about saying go to a local library or apply online or ring this number, which is answered by somebody who sort of sounds like they're off that Little Britain computer says no type sketch. So the migrants and successful asylum seekers are really vulnerable to that. Because even if you're sort of speaking fluent English and you're really on top of your game, um, you still might get messed around by them. So carrying on, the yeah, go on.
I was just going to add a couple of points in if I can, because I think another issue is homelessness law isn't understood by a lot of housing officers,
Yeah,
let alone then you add in sort of immigration law into that, and housing officers don't know what to do because they don't know what to do under the normal law that they should be working under, let alone when you've got law that's quite quick changing. So the Home Office will often make quick amendments to it. They'll have then change sort of the Homeless Code of Guidance potentially. And I think it's very housing officers aren't trained or equipped to deal with it.
No,
And so it's not only that the client doesn't understand what's going on and they can take advantage of that, but they don't understand what's going on.
no, quite right.
And just on the point of like language and the gatekeeping side of things, I think, and that it's sort of a lot more prominent with this cohort of people is I think, and this is coming, I work with lots of people with lived experience and multiple disadvantage, and a lot of those are ex-asylum seekers. And the racism that they often face within sort of from local authorities is huge and from local communities. And when it's mentioned, it's not taken seriously either, because it's just put down to the fact that they are struggling because they've just come from another country or they don't understand. And like, it's actually not, you know, they can understand whether someone's being racist towards them. So yeah, I just wanted to bring that in and then highlight that there's a few questions for you as well in the chat.
Yes, I'll jump onto those in a sec if that's okay. And thank you for that point. I because it is difficult for housing lawyers, sorry, housing officers and housing lawyers too to understand what the law is, because it does change a lot, and I'm having to read these judgments and watch videos and things in order to clarify things. And if you ask me a question about housing law, you know, the odds are I might have to say, well, Beg, give me a little while. I'll come back and answer that later. I don't know the answer off the top of my head. Um, so then I've said that the other problems faced by asylum seekers are that yeah, the lawyers they've been dealing with until then are often asylum or immigration specialists who don't know about housing and therefore are unable to assist directly in challenging a failure. Then they're faced with the same thing that so many people. I was talking with two people today who weren't asylum seekers, but they spent months trying to find solicitors, and they were told by everybody we haven't got capacity, which may well have been true. Uh, and so it's even worse if you're trying to find a lawyer to deal with something specialist. A lot of solicitors who deal with housing, as soon as they hear immigration, they'll start thinking, "Oh, I don't understand that, but I'll leave that one." Then another one. I mean, this goes without saying that the asylum seekers are unlikely to be unable to afford to pay for lawyers privately, so then they're stuck in the looking for legal aid lawyers. And then also they're up against it with the time limit because the Home Office had a policy of saying they'd allow you 28 days to, it's called a moving on time, to get to find somewhere yourself. So you've got 28 days to go to a council and get rehoused. And I dare say, you know, it probably works in a lot of cases. I only deal with where it doesn't work. So I apologise to all the people that have helped asylum seekers with homeless applications and succeeded. Now, they did say that they were going to extend that to 56 days, um, but the client who came to me last week, which led me to write this, he got a letter in June saying 28 days. So I think that may not be um, observed properly. What I'll do is I'll pause before I come on to local connection, and I'll just talk. I'll just look at the comments we've had coming in. Sorry, it's taken me a while to address your comments. Those are we've got. So we've got Katie's got a question here or a comment. Um, don't they have to stay in the first safe country they go through? I was told by a solicitor that they are meant to, rather than coming all the way here. I'm just interested. Yeah, a that's an immigration point, which is often, and I don't quite understand it. I think that the argument would be that if you've made it to France, if you come from Iraq and you've made it to France, which is a safe country, why should you then be entitled to come to England and say, I want to claim asylum here when you were safe in France? And the answer is, um, again, this is showing the gulf between immigration lawyers and housing lawyers. But my understanding is that our treaty obligations, which lead us to have to accept asylum applications from people, recognise the fact that people may want to apply to country A rather than country B, and probably the French are quite keen to encourage that as well, because otherwise they get stuck, or Italy or Greece get stuck with everybody. because those are traditionally safer countries than the originating country. So I think, Katie, the answer to the question is they don't have to stay in the first country they go through. Um, and it may be that the government would like them to, but I think they have a right to say no. I've got, one thing is a lot of people speak English rather than, I mean, if you come from the Middle East, say, and I may be wrong, I think obviously there are parts, Lebanon and places, I think has a history of French influence, but a lot of people speak English as their second language and they don't speak German or French, and so it may be an incentive to come here. A lot of people, I think, may want to go to America in the long run, which I think is seen as a sort of land of opportunity and places where destination. So England may be seen as a step closer to getting there. I don't know. I mean, it's just a question of. Uh, I mean, I suppose if you were fleeing from England, and you might not want to stay in France if you had family in or friends in Sweden, so you might end up travelling from there and not expect to be turned back. So that's as close as I can get to answering that one. I hope that does. And then Tiff's put the question is, why are asylum seekers allowed to throw away their identification, sort of throw away identification, and solicitors allowed to put in legal aid applications for them, but refuse to put in applications for tenants? Yeah, I don't know the answer. I
There's a
suppose.
follow-up.
Oh, sorry, Shanna. Thank you. With only, sorry, I'll move this down a bit. With only title, first initial, surname, and bank card on the address and bank statements, but has a utility bill with title. Is that the follow up? Um,
Yeah.
do you understand? I'm not quite sure of the link between. So, but we've got that one. I was with you until you got refused to put an application for a tenant, i.e., a non-asylum seeker with a housing problem, presumably, and then it says with only title, first initial, and surname. Maybe you could just clarify that one, Tiff. I don't quite know what you mean, but if you're, I mean, I think anyone's allowed to throw away their. I,
It's versus. So,
oh, thank
uh,
you.
asylum seekers allowed to throw their ID away. So this is allowed to put in legal aid applications for them, but refuse to put in applications for versus a tenant with only title, first initial, surname on bank card, and no address, etc. I think.
Oh, that makes more sense. Um, so basically, why is an asylum seeker allowed to apply without the things that a non-asylum seekers has to do to get legal aid? Is that the question?
I think that's the point being made, but I don't know any asylum seekers who throw their ID away. I know asylum seekers who have had their belongings stolen, like they've been mugged and it's been taken from them or they've lost them. But I don't know any asylum seekers that have actively thrown away ID because I think often they try to keep a lot of the important paperwork because they know they need it to speed up sort of settled status and things. But sorry, because I've taken it over, and also apparently V is vulnerable tenant.
Yes. Um, so I think it may be. Well, I mean, I'm not aware of solicitors. I mean, if an asylum seeker or successful asylum seeker came to us and didn't have proof of income or proof of ID, I would have to come up with some explanation for it because the answer to the question is if within the legal aid regulations, it does say the starting point is you have to get all this proof, and not necessarily proof of ID. That's more for getting information through a subject access request to a council and so forth. They want a photo ID and an address ID. So solicitors often ask for that. But the bank statement stuff is a real pain. But hidden away, not too far from public view, though, is the proviso that if there's a good reason, you don't have to get that. And it says, for instance, if the client is homeless or has mental health problems, which you think, well, hang on, that covers a hell of a lot of people. In fact, just about every, if we're dealing with homeless people. But the danger is the legal aid agency. If I was to merrily say to the legal aid agency, oh, I've stopped getting proof of income for all my homeless clients because they're homeless, they would say, no, we meant sort of street homeless and all their things got washed away in a storm or something. It has to be a bit more than just they're homeless plus they suffer from a mental health problem. There will be people who are sort of suffer from an extreme mental health problem, which means they lack capacity. So if I say to somebody, "Can you bring in your bank statement?" The best I'm going to get is something that may be 3 or 4 years old or something, and it's impossible to get them to go to the bank. So I take the risk there, but most solicitors won't take the risk. But Tiff, I think that this applies to everyone, and most solicitors would be reluctant to take on a case for an asylum seeker or a successful asylum seeker in those situations, and they probably wouldn't need to, because the one advantage that the asylum seekers often have is that they do have some paperwork indicating that they have just been through the asylum process, which may mean that it can be shown that until recently their only means of income was money from the Home Office. Um, so that's that one. And then I think that's all the questions so far. So if I can,
I
uh,
think there's a separate one from Tiff.
is that the last? Where's that one? Can
It's
you?
the last two. So should a bank card with just the title, first initial and surname, with a bank statement with no address on, utility bill with just the title, first initial and surname be okay,
Oh, I'm
along with
sorry. So
two
you,
forms of
yeah.
photo ID for a claim to be put in for legal aid? Surely the solicitor could have put in application and tried, knowing it was a vulnerable person, vulnerable tenant does have
Sorry.
mental health
Yes.
problems. Yeah.
Sorry to both of you for being slow on that one. Yes, you're right. The solicitor should have appreciated those things. And when you say vulnerable, I mean, again, vulnerable is a term uh, that's quite wide. And you could say that most people who are dealing with the sort of problems we have are vulnerable in one sense. But you've really got to be close to lacking capacity to before a solicitor will risk doing this. And the reason is because the solicitor, on a legal help case, which is the advice and assistance part of legal aid, will generally risk not getting paid any money at all if they don't get these things right when give the legal aid agency all the details they want. It's the thing you least want to see after doing £2,000 or £3,000 worth of work and spending a similar amount of money on interpreters and psychiatrists and what have you, to then get told by the legal aid agency they're not paying it, because not only are you out of pocket in terms of getting paid for your work, but you've got to come up with the money to pay the disbursements, which to my mind is absolutely outrageous. But unfortunately, that unfairness is passed on to vulnerable people because the solicitors will take a very conservative approach to this problem and will just say, "Oh, I'm sorry, I'm not going to take the risk." Um, and you'd literally have to be satisfied that the person just could not provide it. Um, so Tiff's sorry, I'm not showing the questions. Tiff has added to that. Care leaver years ago and stress, depression, anxiety. Is the vulnerable tenant. Yeah, that's. I mean, the thing is, I agree with you. That is vulnerable, but the question is, just to play devil's advocate with you, a care leaver suffering from stress, depression, and anxiety. Do those things mean that the person can't get a bank statement? Um, it may well do, but it doesn't always. And you'd have to. So I can hear some sound in the background. Is but the point is, I think it's vulnerable. But the thing is, can you satisfy the legal aid agency that it's vulnerable, that the person's vulnerable? Sorry, and it may be that in the absence, if you had a letter from the doctor saying, or some evidence saying this person really was so suffering from such levels of depression they can't go out, they can barely engage with the outside world, that would be fine. But otherwise, they'll probably take a sort of now medical type approach and say, well, that's not that serious, and so we're not going to pay the solicitor. Um, so I'll just go back because we're running out of time, and I think the if I go back to this last bit, I want to just talk about local connection, which is relevant to the asylum seekers problem or predicament. So if I go back to here, uh, now we've talked about local connection before, and if you remember, it's one of the hurdles that you have to cross in order to get a local authority to house you, is that you have to establish that you don't have a local connection somewhere else. Now, without going into too much detail, There's four real categories of local connection. One is you've lived in the area of choice, as choice. You are employed there. You've got close family there. That tends to need to be brother, father, sorry, mother, father, brother, or sister. I think grandparent as well. And if, for instance, you didn't have any other relatives in the country, you might be able to argue that a more distant relative was a close relative, but was a family association. And other special circumstances. I can't think of any off the top of my head right now, but stop me if anyone else can. So anyway, you go to a local authority, and this is a problem. You go to a local authority and they turn you away and say, you've got a local connection somewhere else. We don't think you've got a local connection here. Um, Now, they're not supposed to do that. What they're supposed to do is ask themselves, are you home? Are you eligible for housing? Are you homeless? And are you in priority needs? Now, if they have reason to believe that the answer to any of those questions is yes, uh, then they have to provide temporary accommodation. They can make a referral to another authority if they think they have a local connection there, but they can't just turn them away. Now, in the case I was dealing with, the person had been placed in home office accommodation in Lancashire, in fact, in the town where my father was born, and didn't want to stay there because he'd previously lived in a London borough. And he'd actually lived in the London borough long enough to have a local connection there. But when he came to the council in London and said, I'd like to apply here, I've got this letter from Serco, it was addressed to him at an address in Lancashire. The person looked at it and said, now you're Lancashire's problem, not ours, and turned him away, which was unlawful on two levels. One is they shouldn't have done that, they should have accommodated and made inquiries. And the second is that he arguably did have a local connection with them and shouldn't have been turned away. Uh, but you try and argue that over the phone if you don't speak in a language you're not familiar with somebody who's pretty much made their mind up anyway. Um, so that is a really difficult problem that you face. So the answer to the problem, or the solution to the problem, in most of these cases where somebody is getting messed around, is these four steps, which I think come up time and again in homelessness law. Number one, send a letter in accordance with the pre-action protocol. Now you may need sort of 1A and 1B, which is find a solicitor to write the letter for you. Because if I say to somebody, would you mind writing a letter in accordance with the pre-action protocol, which is review proceedings, they probably, it's a bit like asking somebody to sort of replace the engine in someone's car. It's you've got to know what you're doing. So you've got to send a letter in accordance with the pre-action protocol, get a legal aid certificate, find a barrister to assist with the case, and then issue judicial review proceedings. If you can follow those steps and the person is being messed around in the way I've described, then you should be able to get an order requiring the council to accommodate. And I just very briefly, there's another sort of, if you think of this like a game of snakes and ladders, there's another snake you might hit, which is that the council say, oh, all right, they respond to the letter before action. And this happens with people who aren't asylum seekers. And they say, all right, you want to be like that. We have decided that you're not in priority need because we've asked you about your medical condition and you told us about it and you had a letter from your doctor and an appointment letter from the hospital. And we've sent that to our medical advisor who says there's nothing wrong and you're not vulnerable, which presents a problem because then the duty to accommodate under Section 188 drops away because they only have a duty to accommodate until they've made a decision. And if that decision is a rubbish decision, you've got to challenge the decision rather than try and get mandatory accommodation. So what you then have to do is the same steps but slightly different. Request a review of the negative decision. Request accommodation pending the outcome of the review. That should have said. Then send a different letter in accordance with the judicial review pre-action protocol. Obtain a legal aid certificate, and I didn't put there, get a barrister, and then issue judicial review proceedings. So you're basically then in the same position because what you're saying is, I've asked for temporary. They've made a rubbish decision on my case, which is unlawful. I've challenged it. I've asked them to accommodate me pending the outcome. They've said no, so I'm asking, just as I would have done before, for an order requiring them to house me. It gets a bit more complicated if they complete the review by upholding it and you then have to appeal, but I'm not going to go down that road. It's unlikely that they would be stupid enough to try and do an instant 202 decision the same day, but it does happen. So the steps which anyone who out there is thinks they're about to get granted asylum, or anyone who's advising somebody, they need to be aware of these steps as soon as and take them as soon as possible. So really identify, this is, I mean, obviously, I'm sorry, this is perhaps insulting people given the difficulty of doing this, but identify housing solicitors who may be able to take a challenge or deal with a challenge if the local authority do mess around. So you could make inquiries. Be ready to apply for a legal aid. Be ready to apply for legal aid if you do need to challenge, and that's to say, get your proof of income ready, and be, so you can give that to the housing solicitor. Get all your medical evidence together. Apply for copies of your medical records. It may well be that you don't have any medical records, especially with mental health problems. These things usually go undiagnosed, and it's only when you get a psychiatrist to examine somebody for the first time the problem actually gets revealed. But it's unlikely you've got a GP report giving a detailed mental health problem. But you could have something like a personal, well, actually you wouldn't if they just got asylum. They wouldn't have a benefits claim. But there may be some evidence somewhere. Oh, I tell you where it would be. Often in immigration applications, there'll be a psychiatrist report which is used to decide whether the person's account of what they say happened to them in the country they've fled is true or not, and what impact it had on them, and what going back's like to do. So that sort of thing would be useful. And then be ready to send the above letters to the council, threatening judicial review if necessary, before instructing a solicitor. Now, again, it is possible to write a pre-action protocol letter yourself, and there are ways to do it. Now, there's this video here, which I'll put a link to at the end, which is really, really good and goes into more detail about these legal issues. And that's the one produced by Garden Court Chambers, with the assistance, you can see her here, of Polly Glynn, of Dyson Pierce Glynn Solicitors, who have got a scheme going, which is really, really good, called the Pre-Action Protocol Scheme, or forgive me, words to that effect. And Polly talks about it on this video. And basically, they will help you write a pre-action letter, or show you how to do it, and even I think they'll check it for you when you've done it. Um, so I would recommend anyone who's interested in this to watch that video. And then what I'm going to do next time, which should be next week now, I guess, is I have been working on it. I'll give you, if you've managed to stick with me this long, the reward is you get a little preview of the judicial review pre-action letter, which I have prepared, and I'll talk about it in more detail next time, so that if you want to, you can basically edit this and send it off, um, and then you can try and find a solicitor, and the solicitor's going to be more likely to take the case on because they'll say, oh, I don't have to do the pre-action letter, I can just go straight to a legal aid certificate, and that's one less thing to worry about. So that is now, it's now 8:29.
Think
Halfway, yeah, sorry, Shannon, please.
No, I was just gonna say, I think as well, like, because when you first started, it was like the solutions to this problem. In my head, my first thing was like, actually, it's the education of like people's legal rights, and I
Yeah,
think people's legal rights in this country, because housing officers don't know, like British-born people, what their legal rights are, and so you know the discourse you were talking about, sort of with Reform and other media channels and other political parties, um, and the racism that comes from it. I think that often comes from people in this country not they're getting their rights denied, and it's not that other people are getting their rights listened to, they're also getting denied, but there's no education about what people's rights are and what they're legally entitled to, so that it just everything feels unfair, and that's because of the gatekeeping and the lack of knowledge that happens. um Yeah, that's all I was going to say, really.
No, I
If that makes
agree,
sense,
and
hopefully it
hopefully
does.
the things that we're doing on these live streams and in between will hopefully be part of a process where people will see legal rights as being something that people should know about and not just something that a lawyer tells you about when you fall foul of the system. Um, there's practical, in practical terms, though, I mean, I think that maybe in the future people will look back and laugh at our society to think, isn't it funny that they didn't teach them legal rights at school? And I don't mean legal rights in terms of fascinating things about the law, which you sort of do in a law degree, which is not actually all that fascinating, but the issue of what to do if your legal rights are, what your basic rights are, and what to do if they're interfered with. Like, can you, if what do you say to a police officer who asks you for proof of ID, or to come with them to the station? Are you obliged to do that? And what is your right to benefits or housing? And but the practical thing, and this is the other half of the education, is knowing how to enforce your rights, because the danger is that if you just teach people about rights, it becomes a bit like unreal, because you can say, well, you have a right to all this. But when you say, well, hang on a minute, I went to the council the other day and they laughed when I told them that. Um, what do what do I do? And so the question is, well, you teach people how to write letters, and ideally, well, I mean, it sounds crazy, but ideally, we ought to have a system where a situation where the legal system meets people halfway, and it shouldn't be necessary for us to go through all this 18th century nonsense to get a judicial review off the ground. The person ought to be able to go to the court and say, this has happened to me, and then the court would translate that into legalese. And this would require a completely different approach from English law, which more like French sort of examining magistrate type law, where the in England the judge acts as a sort of umpire in some cricket game, and cricket being the useful analogy because it's a sort of game played by middle class, well, generally middle class people and they're not really interested in the issues, so it's just the rules of the game have been played. Whereas what you really want is somebody to adopt what's called anxious scrutiny and look at that. But I can see that's quite a long way off and would require a lot more resources, um, and would put lawyers out. Well, I don't know. People like me might get jobs working within the courts system, which is where you think actually we should be, because you'd have a court system which is actually dedicated to upholding rights rather than deciding disputes about rights. But sorry, Shannon, that's a bit of a rant in response to your point. But I totally agree with you. Um, and to some extent, we'll never be able to, unless you get a culture within schools that teaches people their rights and how to implement them, and a system which meets them halfway. Um, it's going to be difficult to achieve that, but we just have to keep trying and see where we go. But I hope that's useful for everybody. And that I don't think there's any other questions. So unless you guys have any questions, I'll wind up for tonight, and hopefully see you on Thursday for Mike's live stream. And again next Monday I'll be back, and hopefully with a series of things you can do to not just asylum seekers, but letters you can write if you get turned away from a local authority or something. So if that's okay with you guys, I'll say goodbye for now and finish this show. So bye.